We are definitely living through an incredible boom in generative AI. I mean, it's a tech revolution that really seems to be reshaping industries almost overnight.
Absolutely.
But, amidst all this rapid growth, a surprising truth has popped up, this explosion of innovation. It's also unleashed a new and frankly incredibly complex legal firestorm.
Hmm.
We're seeing this unprecedented wave of lawsuits hitting the big names like Google, Microsoft, OpenAI, but also innovative startups, Anthropic, Perplexity AI.
Right. They're all in the mix.
And this isn't just like legal back and forth. It feels like a really crucial moment that's going to fundamentally define the future direction, the accessibility, even the economic model of AI as we know it.
It really is foundational.
The main battleground, the central fight we're seeing, it's got to be over copyright infringement, right?
Without a doubt. That's the core issue right now.
You've got authors, music publishers, news agencies filing suit. They're claiming their valuable content was used illegally to train these massive large language models, these LLMs.
Yeah. Without permission, without payment.
Exactly. No permission, no payment. It's a direct challenge to how these models actually learn.
And what makes this particularly fascinating, I think, is the counter-argument from the AI companies.
Okay.
They're invoking the fair use doctrine. It's a well-known legal concept, but applied here, it's new territory.
So what's their angle on fair use?
Well, their argument is that using these protected materials was transformative. That's the key word. And vital for innovation.
Transformative how?
They claim they weren't just reproducing the content, but learning linguistic patterns from it, creating something entirely new. The AI isn't spitting back the book, it's learning how language works.
Oh, okay, I see.
So this whole situation, it's a real stress test for our current IP laws. It's forcing us to find that tricky balance between encouraging this amazing tech innovation and, well, protecting creators' fundamental rights.
It sounds like more than just a legal debate.
Oh, it absolutely is. It's a broader renegotiation of how we value information, how we value creativity itself, really, in this digital age. And it's important to remember, too, the battle isn't just limited to copyright. That's the big one, sure. But we're also seeing fierce patent battles for the AI hardware itself.
Right, the chips and things.
Exactly. And serious privacy violation concerns related to how data is collected, even emerging trademark issues. The legal landscape is much wider than just copyright. It shows how deeply AI is touching every layer of the tech ecosystem.
Okay, let's try and unpack this then. Our mission today, let's say, is to cut through some of that legal jargon, explore the really significant cases that are defining this space, and try to understand what these battles mean for you listening and for the future of technology. So to map this evolving battlefield, where should we start? Who's really in the crosshairs right now?
Hi, the AI legal battlefield. Who's in the crosshairs? Well, when you look at the lawsuits, at the data, it's pretty clear. Most of them are concentrated on a few leading AI companies, the ones really pushing LLM development.
Makes sense.
OpenAI, because of ChatGPT's massive popularity, its ubiquity, it's by far the most targeted.
Right.
Microsoft often shows up as a co-defendant. That's largely down to its huge investments and its strategic partnership with OpenAI. So they're number two, really.
Okay. OpenAI and Microsoft leading the pack.
Yeah, but it's not just them. Companies like Anthropic, Meta, even newer players like Perplexity AI, they're also facing a substantial number of cases, especially from authors and music publishers. Those groups are very active.
Okay, so with that sort of map of the landscape, let's dive into some of the most prominent cases. I'm really keen to understand the specific legal challenges each company faces, because they're not all identical, are they?
No, not at all. Each case often brings up slightly different nuances. Two key legal battles, examining the front lines. A, OpenAI and Microsoft. In the eye of the copyright storm.
So OpenAI, as a real pioneer in generative AI, it feels like they're constantly at the center of these major disputes, often right alongside Microsoft.
They really are front and center.
One of the highest profile examples has to be that lawsuit filed by the New York Times back in December 2023.
Oh yeah, that one made huge waves.
They're accusing both companies of widespread copyright infringement, right? Saying they used millions of the Times articles to train their models without asking.
Precisely. And the Times is arguing this directly harms their business, their ability to generate revenue and protect their journalism.
Yeah.
It's an existential threat in their view.
And then on top of that, we've seen these class action lawsuits from well-known authors. You mentioned Sarah Silverman, John Grisham, George Saunders. big names.
Yeah, quite a list.
And their claim is similar, isn't it? That their books were basically ingested by these AI models, forming the backbone of their knowledge. Again, no permission, no compensation.
Exactly the same core argument. My work was used without my okay and without paying me for it.
So what's the latest development there? I heard something about consolidating cases.
Ah, yes, that was a big step. In April 2025, a U.S. judicial panel ordered the consolidation of 12, I think it was 12 copyright cases against OpenAI and Microsoft.
12. Wow.
Yeah, all brought together into a single court in New York. The rationale was to streamline proceedings and avoid conflicting rulings. Makes sense.
Yeah, avoids chaos.
So it effectively combines the author cases and the media cases, like the Time suit, into what The Guardian called one massive legal battle.
Okay, so one giant case now.
Pretty much.
Oh.
And this centralization is going to have a huge impact on how everything proceeds. It could potentially set a single, really binding precedent for creators and AI companies.
Defining the rules of engagement, basically.
That could very well define the economic relationship between them for the foreseeable future.
So the outcome of that case against OpenAI and Microsoft, it's going to be massive for content creation, consumption. But like you said, the legal landscape is shifting elsewhere too. Anthropic's recent case seems really important for understanding that fair use idea we touched on.
Testing fair use and training limits.
Right, let's look at Anthropic. They make the Claude chatbot. And their case, as you say, seems incredibly impactful, especially for how courts are looking at fair use.
It really is. There was a landmark ruling back in June 2025. Federal Judge William Orrick. He delivered what looked like a significant fair use victory for Anthropic, at least on one front.
Okay, a victory. How so?
Well, the judge ruled that Anthropic's use of copyrighted books to train its AI model was, and this is the quote, exceedingly transformative.
Ah, transformative again.
Exactly, because the goal wasn't to reproduce the original books, but to learn linguistic patterns from them, to create something new.
So, like the analogy of a human reading books to learn to write.
That's a good way to think about it, yeah. You study countless books, not to copy them word for word, but to develop your own style, your own voice. The judge seemed to buy that argument for the training part.
So that's a big win for AI companies, potentially.
It is, and it could set an important precedent for other companies focusing purely on that training aspect. However...
There's always a however in law, isn't there?
Hey, usually,
Yeah.
it wasn't complete victory. And this is where you see those crucial nuances, the fine complexities, as you put it.
Okay, what's the catch?
Judge Orrick also ruled that Anthropic infringed on authors' rights by, quote, storing pirated copies of books in a central library. And he ordered a trial specifically on that charge.
So training might be okay, but holding on to pirated copies, not okay.
Exactly, that's the distinction. While the act of learning from the data might be transformative fair use, the act of acquiring and storing potentially illegal copies of that data is a completely separate copyright issue.
Okay, that makes sense. It's like you can learn chemistry from a textbook you borrowed, but if you photocopied the whole thing illegally, that's different.
Precisely. Your brain learning is one thing, training. Keeping the illegal copy on your shelf is another, storage. And this distinction is incredibly important. It suggests AI companies might need to seriously rethink how they get and manage their data, not just what the AI produces at the end.
So the source of the data becomes critical.
Absolutely. And just to add, Anthropic also faces a whole separate lawsuit from music publishers. So their legal fight is definitely not over. They could still be looking at, billions in damages if they lose that piracy storage case.
Wow. What's fascinating here is how the court is starting to draw these incredibly precise lines, isn't it, between training and storage?
Exactly.
It really clarifies the complexity, the sort of evolving nature of these claims. That feels like a key takeaway here.
I agree. It shows the courts are grappling with the specifics, not just making broad pronouncements. See Perplexity AI, Answer Engines, and the media divide.
Okay, moving on then. Let's talk about Perplexity AI. They position themselves a bit differently as an AI-powered answer engine.
Right, not just a chatbot.
And they use this unique technology, Retrieval Augmented Generation, or RAG. Can you unpack that a bit?
Sure. So RAG is different from just relying on the model's pre-trained knowledge. With RAG, the AI first actively searches for relevant, up-to-date information from external sources, usually the web.
Like a quick Google search built in?
Sort of, yeah. It retrieves that information, and then it uses that retrieved data to formulate its answer. The goal is to give you answers that are current and directly sourced.
Okay, sounds useful, but
But this approach has really angered news organizations in particular.
why is that?
Well, the core issue is that users can get the answer directly from Perplexity, often with summaries drawing heavily on the news site's content, without ever clicking through to the publisher's website.
So it bypasses their traffic.
Exactly, which directly hits their advertising revenue, their subscription models, basically their whole business. It's like getting the Cliff Notes without buying the book, maybe, or getting the answer from the librarian without checking out the source material.
Okay, I see the problem for publishers.
Yeah. So in December 2024, News Corp, they own the Wall Street Journal, New York Post, big outlets, they renewed a lawsuit against Perplexity. They accused it of massive unlawful copying.
Renewed, so this wasn't the first time.
No, it suggests an ongoing dispute. And then, more recently, August 2025, the Yomiuri Shimbun, which is Japan's largest newspaper, filed a similar suit. They claim Perplexity used nearly 120,000 of their articles without permission.
Wow. So these cases are less about the training data, like with OpenAI or Anthropic,
Exactly.
and more about how the AI is using and presenting information it pulls directly from current web content.
Precisely. It's about the output and its immediate impact on the source's business model, more than the long-term learning process.
This raises a really important question then. How do traditional business models, especially in news, adapt when AI can just provide direct answers sourced, essentially from their hard work?
That's the multi-billion-dollar question, isn't it? Deep patent battles in AI hardware. NVIDIA and Intel.
Perplexity AI really shows how AI challenges existing content models.
Yeah.
But you mentioned earlier, the legal fight isn't just about words and images. It also goes down to the metal, right? The hardware powering it all.
Absolutely. Let's shift gears to that. There are some fierce legal battles playing out in AI hardware, too.
Dominated by companies like NVIDIA and Intel, I assume.
They're the big players, yes.
Yeah.
And they're facing intense legal challenges, but mostly in the realm of patents, not copyright.
Okay, so NVIDIA, they're the leader in AI GPUs, those graphics processing units everyone wants. What are they facing?
Well, they're facing multiple patent infringement lawsuits. For instance, back in September 2024, a smaller Texas company called .sockets Inc. filed a suit.
Sockets, okay.
Yeah. They accused NVIDIA and Microsoft, interestingly, of stealing its data processing unit, or DPU technology.
A DPU, what's that?
It's a specialized processor. It's designed specifically to handle moving data around efficiently, networking tasks, really important in big data centers and these massive AI clusters. Offloads work from the main CPU.
Got it. So Sockets claims NVIDIA and Microsoft use their DPU tech without permission.
That's the allegation.
Okay.
And then, even more recently, August 2025, a German supercomputing company, Partec AG, filed a lawsuit. They're trying to block the sale of NVIDIA's DGX systems. Those are NVIDIA's high-end AI server boxes in 18 European countries.
Block sales, that's serious.
Very. They allege infringement of a patent related to modular computing architecture, basically how you design and connect components in these big systems.
So these cases, they highlight that tension between the giants like NVIDIA and maybe smaller innovators.
Exactly. It shows that even the foundational hardware underlying AI isn't safe from these kinds of intellectual property disputes. It's not just about the software and data.
And what about Intel? Are they facing similar things?
Intel has its own challenges, yes. Different angle, though. In August 2024, the software company Anaconda sued Intel.
Anaconda, the data science platform people.
That's them. They accused Intel of misusing its software to develop AI platforms after Intel's license to use that software had actually expired.
So that's a software copyright issue related to hardware development.
Precisely. It's about violating the terms of a software license agreement, which is technically copyright infringement. Shows the complexity even in software licensing needed for hardware work.
Okay, wow. We've explored cases across the whole spectrum, from the LLMs and content right down to the chips and software licenses. So what does this all mean for the AI industry as a whole? And maybe more importantly, for you listening, trying to navigate this, what are the key takeaways? What should you be watching? 3, future trends and implications for the AI industry.
Well, I think the first thing is to see this wave of lawsuits not just as, isolated disputes between companies. It's really part of a much broader renegotiation, I'd call it. A renegotiation of the value of data and intellectual property in this age of AI.
Renegotiation. How so?
Well, the surprising implication here is that huge amounts of content that we maybe thought of as free or just out there on the internet might effectively be remonetized, revalued as commercial assets specifically for AI training.
Ah, so the web isn't just a free library anymore. It's potentially a valuable training ground that needs to be paid for.
That's the direction things seem to be heading. It could fundamentally alter the economics of the internet as we know it.
Okay. So what key trends are emerging from this renegotiation?
I see several key trends shaping the industry right now. First, definitely the rise of licensing deals.
We're seeing more of those already, right?
Yes, AI companies are starting to proactively strike direct licensing agreements with content providers, partly to get good data, but largely to mitigate these legal risks.
Like OpenAI's deals with the Associated Press and Axel Springer.
Exactly. Those are early examples of what could become a new industry standard. It's not just about paying creators. It's a fundamental shift, potentially reshaping the whole value chain for content.
Okay, licensing deals are number one. What else?
Second, there's a really strong push for clarification of the fair use doctrine. Court rulings, like that Anthropic one we discussed, they'll eventually lead to clearer boundaries for what constitutes fair use in AI training. It's likely going to force companies to be much more transparent about documenting their data sources.
Right, where did you get this stuff?
Exactly. And maybe differentiate between different types of use, like training versus storage versus output generation.
More granularity. Makes sense. Third trend.
Third, inevitably, government regulation. It's definitely on the horizon.
Yeah.
Governments, regulatory bodies all over the world, they are watching these cases very closely.
Understandably.
And this might well lead to new legislation that specifically governs how data is collected and used in AI training. We saw Japan amend its copyright law back in 2018, specifically to encourage AI development, so there's precedent for legislative action.
So laws catching up with the tech?
Trying to, yes. And finally, fourth, all these legal risks. They're pushing companies to focus more on synthetic and proprietary data.
Ah, data they create themselves or clearly own.
Precisely. Investing more in creating high-quality synthetic data generated by AI itself, essentially or relying on data sets they absolutely know they have the rights to. This reduces their dependence on just scraping content from the open web, which is proving legally hazardous.
Okay, so licensing, clear fair use, regulation, and a shift towards own or synthetic data.
Those seem to be the big ones shaping the immediate future.
If we connect all that to the bigger picture, it really sounds like these legal battles are shaping the very foundations of the AI revolution. They're influencing everything from business models to national policies and even maybe the future of creativity itself.
I think that's exactly right. It's a fascinating, incredibly complex, and really high-stakes transformation we're watching unfold. Outro.
So what we've really unpacked today highlights this core tension, doesn't it? You have the massive, undeniable innovation of generative AI running smack into the established rights of creators and these existing legal frameworks that weren't designed for this technology.
A classic clash.
And these aren't just, dry legal battles happening in courtrooms somewhere. They feel like really foundational discussions about what value even means in the digital age. They're setting precedents that are going to ripple out across so many industries.
Absolutely. And I think the bottom line is the outcomes of these legal battles will ultimately determine who really benefits economically from the AI revolution.
Yeah.
And they'll set the rules of the game, the rules governing the relationship between tech innovators and content creators, probably for decades to come. It's a critical moment of redefinition, truly.
So here's a final thought for you, the listener, to maybe mull over. As AI becomes more and more integrated into our daily lives, and it is rapidly,
No doubt.
consider how these legal outcomes we've talked about today might actually redefine the very concepts of originality and ownership in the digital realm. What new opportunities or maybe what new challenges might this create for you personally, both as someone who uses this stuff, a consumer, and potentially as someone who creates digital content yourself?
It's something everyone will need to grapple with.
Definitely something to think about. Thank you for joining us on this deep dive.